All right, today we're talking about alimony in Florida. Alimony is naturally going to be a very divisive issue. You either want it or you really don't want it. Right? So you're either going to be on either side of that aisle. There's a couple of popular misconceptions that just initially you should understand about alimony. Number one is that alimony is not guaranteed in divorce cases. Just because you're getting a divorce doesn't mean that you're going to get alimony. It doesn't mean that you're going to necessarily have to pay alimony. It has to be proven by one party, and the other party has the opportunity to try to disprove the necessity of alimony. Without showing that proof, you don't just by default get alimony. And, one of the most important things is in these divorce cases in Florida, whenever alimony is awarded by a judge, the judge has to make very detailed findings of fact in the final judgment order. The judge has to specifically talk about the facts that are requiring somebody to pay alimony. Husband makes this much money. Wife makes this much money. These are the husband's reasonable necessary expenses. These are the wife's reasonable necessary expenses. And then there's statutory caps that have to be applied before the alimony amount can actually be calculated. And all of those findings of fact have to be reduced down into a final judgment in order for there to actually be alimony in a case. It's not just by default, you get awarded alimony because your husband makes more money. It doesn't work like that. The other important thing to realize about alimony, and it's another misconception, is that alimony is not just for women in a divorce. It's not just men paying alimony. A man can pay alimony, a woman can pay alimony. It's not a gender-based problem. It's really, if one spouse is making a lot more money than the other, there's a higher likelihood that the spouse that's making more money is going to have to pay alimony. That's the way it works. It's not just from husband to wife, man to woman. It doesn't work like that. So those are two misconceptions that you have to realize and keep in mind when analyzing any divorce case or thinking about getting a divorce. There's a couple of different forms of alimony as well. The most common form of alimony is going to be durational alimony. And that is a set amount of money that might be paid monthly over a period of time that's designed to level the playing field between a couple when they're actually getting divorced. There's statutory caps that apply to that, and we can discuss that in a little bit more detail. There's some other different forms of alimony as well. There's rehabilitative alimony. There is bridge the gap alimony. Those are a lot less common than durational alimony, and they really only apply in very limited situations that really, as divorce lawyers in Florida, we're not seeing a lot of, but it should always be something that's on your radar. When it comes to durational alimony, far and away, the most important factor is going to be the incomes of either spouse. When we analyze a case for alimony, what we want to do is we want to look at first the gross income of both parties to the marriage. And you kind of can get into the weeds on how to determine the gross income. What I hear very often from people, and I just want people to just get it out of your head because it's not going to help anybody. It's not going to help you. If you work a sales job or a commissions job or any job where your income fluctuates, that is not an excuse to avoid alimony or child support. When we look at your gross income, we're looking at the past 2-3 years. We're looking at your total gross income. What was it? Right now, it's 2025. We're going to look at your 2024 income. We're going to look at your 2023 income. And those things are going to come from your tax returns, right? We're also going to look at your year-to-date income for whatever year it is that you're filing for divorce. So if you're filing for divorce in August of 2025, when this video is being filmed, we certainly would look at your year-to-date income. But, if you're somebody that makes a quarterly bonus or an annual bonus or monthly bonuses, we're going to look at how much money you've been making for several years in total. It's not an excuse to say, well, I can't pay alimony because, my base pay is at $4,000 a month and I don't know what my commission's going to be. Cool. Nobody cares. We're going to look at how much money you've been making, and then we're going to kind of extrapolate that into the future. That's how that works. Once we nail down what your gross income is, we got to do the same thing for the other spouse. And again, we're looking at tax returns, we're looking at year-to-date income. And once we have those gross incomes, Then what we do is then we need to calculate the net incomes. And the net incomes are going to be after payroll deductions, mandatory retirement contributions. That's not contributions to your 401k. That's mandatory. So like if you're a member of a union and you're required to contribute to a union pension, that would come out of your gross income, reduce your net income. Other things that reduce your gross income are basically the same things that you pay in your paycheck. SSI, Medicare, taxes, income taxes. We're in Florida, so you don't have a state tax, but that's going to be your net. What's in your W-2. If you own a business and maybe you draw on a salary from the business and you're making those payroll contributions, but you're also taking money out of the business in shareholder distributions. Those shareholder distributions are going to have to be on what's called a K-1 at the end of the year, if it's an LLC, and most likely it's going to be an LLC. So we're going to be able to see how much money your net income is. And the most important thing is really to look at the tax returns, because the tax returns from the previous year are going to show how much taxes you actually paid on those shareholder distributions if you own a business, for example, or your spouse, whatever the case is. So when we're looking at calculating alimony, we want to know your personal income. We're not looking at your business revenue. We're looking at your personal revenue, your shareholder distributions minus taxes, your W-2, your wages, your bonuses, all of those things after tax money. That's your net income. We calculate net income for you and your spouse. Once we have those net incomes, then what we do is we use financial affidavits, which are required in divorce cases. We look at those financial affidavits. You're going to have to do one. Your spouse is going to have to do one. They're going to have to get filed with the court. They're extremely important. And there's a lot of strategy that goes into drafting these financial affidavits, especially any case in which you're either pursuing alimony or you're defending against an alimony claim. The financial affidavits are what the judges are going to use and rely on to try to calculate alimony. The financial affidavit is going to show your gross income. It's going to show your net income, but it's also going to have a list of all of your monthly expenses. And what the judges are looking for is, if you're the one that's defending the alimony claim, the judge is going to be looking for your ability to pay alimony. They're going to be looking for what your surplus is at the end of a month. So if you're making $10,000 a month in net income and all of your reasonable and necessary expenses add up to $8,000 a month, and you've got an extra $2,000 a month surplus, that then becomes potentially what you're able to pay in alimony to your spouse. Now, let's say your spouse makes $4,000 a month, and that's her net income, but all of her reasonable and necessary expenses, also estimating what his or her expenses are going to be after a divorce. Maybe your spouse is going to have to go out and rent an apartment because you guys are selling the house. Maybe they have to go and buy a new car and have a car payment. They're going to be paying insurance on that car. All of those expenses, even if they're not currently paying them right there during the divorce, those things can be estimated so long as they're reasonable and necessary. They can be estimated on that financial affidavit. So let's say they're making $4,000 a month net, but their reasonable and necessary expenses add up to $6,000 a month, meaning that after the divorce, they're going to be operating on a $2,000 a month deficit. Well, now when the judge looks at the two financial affidavits, they look at yours and they see that you've got a surplus of $2,000, and they look at your spouse's and they've got a deficit of $2,000. It's going to make sense for the judge to say, you're going to pay $2,000 a month alimony. So now you're going to break even at the end of the month, and your spouse is going to receive $2,000 a month, and they're going to break even. So that's what's considered, a fair and equitable result. It's not fun. It might not be the result you want, but it's fair and it's equitable under the circumstances. So that's why the financial affidavits are important. The threshold criteria for whether or not a judge is going to award alimony from one party to another is going to be something called need and ability to pay. And I just talked about those things. What does your spouse need in order to break even? And what are you able to pay for you to break even? The law is very clear on this, and there's case law on this in Florida. Nobody, no party, whether it's man, woman, husband, wife, doesn't matter, no party in a divorce, as a result of a divorce, should pass from wealthy to poor or from poor to wealthy. That's not the point of a divorce. It's not to put one person way up above the other. It's not punitive. It's not to punish somebody. It's to try to get both parties on more of a level playing field. So that's the idea of it. That's the major concept of alimony, is to level that playing field. And the biggest threshold criteria, again, need and ability to pay. If somebody is pursuing alimony, they have the burden of proof. They have the obligation to present evidence and prove that their spouse has the ability to pay alimony and that they need alimony. If the person that is pursuing an alimony claim is going to go to court and admit that they're going to be moving in with their parents, not paying rent, and that they're going to be working a job and making decent money, and that they have a paid off car with no car payment, and they actually don't have a deficit at the end of the month, the other person that they're divorcing could be making $1 million a year. It doesn't matter. The court is not going to order that person to pay alimony because the person that is seeking alimony has not proven that they need money. So you have to prove that you need money if you want alimony. It's not guaranteed. You don't just get it. Even if the person pursuing an alimony claim can demonstrate with evidence that they need money, the court is not going to award alimony if the person that they're seeking the alimony from does not have the ability to pay it. So for example, let's say your spouse is making $5,000 a month net and you're making $5,000 a month net. You're both making the same amount of money. Even if your spouse says that they need an additional $2,000 a month to break even, the judge is not going to make you pay alimony because you're in the same financial situation. So even though they've proven with evidence that they need money, they have not proven that you have the ability to pay it. So they have to prove both things. And if you're the one defending the alimony, your whole strategy in these cases is to prove, look, I don't have the ability to pay it. Yes, I agree. They have a need. I don't have the ability to pay. Once you take my net income and you subtract my reasonable necessary expenses, I got a deficit too. I need money. I understand that she needs money, but I need money too. We both need money. If that's the situation, nobody's going to be paying alimony. Now, when we talk about reasonable and necessary expenses, those things that get claimed on the financial affidavits that either increase somebody's deficit, factor into somebody's surplus, they're going to be scrutinized and analyzed by the courts and by the divorce lawyers on either side. You can't just fabricate expenses on there to try to show that you don't have an ability to pay alimony. If it's not going to be something that's reasonable or necessary to live, or if it wasn't something that you've been doing in the past, then it's probably not going to be believed. It's probably not going to be included as an expense. So for example, if you're in the middle of a divorce and you're the person that's making a lot more money than your spouse, and you know your spouse is going to be making an alimony claim against you, and they're going to have the burden of proving that you have money at the end of the month and that they need money at the end of the month, it's not going to be a good thing to do to go out and decide that now you want to start skiing all the time and start booking trips to Aspen every month to go ski and say, well, because I have a ski hobby, I no longer have the ability to pay alimony. Judges probably aren't going to believe that. And they're going to take that ski expense off your financial affidavit and show that you do have the ability to pay some money. Now, maybe you've been skiing every month for 10 years and you've been doing it over a long period of time. And that's something that you do for yourself. That's not something that you want to stop now that you're getting divorced. That judge then may allow you to claim that expense because you've been doing it for so long. Who is the judge to tell you that you're not allowed to go skiing anymore? So there's a lot of different factors. There's a lot of different things that get weighted into whether or not an expense is reasonable or necessary for purposes of reducing your income or increasing your deficit. And that's what we do as lawyers, is we have to analyze all that stuff. And that's why the mandatory disclosure process is so important in divorce cases. With all that being said, even if your spouse can prove that they have a financial need for alimony and that you have the ability to pay alimony, there's also going to be some statutory caps. And this is the result of a law that passed in 2023 in Florida. There are now caps on alimony. Before that, it used to be unlimited in duration, but now it's limited in duration based upon how long your marriage was. So if you were married for less than 10 years, the maximum alimony you could pay would be half the duration. So let's say you were married for exactly 9 years. We would tell you that your worst case scenario for how long you would have to pay alimony, if it is awarded, is going to be 4.5 years. It's going to be half the duration of a short-term marriage. Once you hit 10 years, I'm talking 10 years and 1 day, it goes up to 60% of the duration. So if you were married for, let's say, 12 years, what's 60% of 12? Let's call it 7 years. I don't know. Somebody can do the math, fact checking on that. But the point is that you're going to be paying alimony for 60% of the duration of a moderate term marriage. That's a marriage between 10 and 20 years. If you're married over 20 years, regardless if you're married 40 years, 50 years, whatever, or even 21 years, it doesn't matter. Once you hit that 20-year mark, now you're in the 75% category. So it's kind of like income tax rates. Like, just like the more money you make, the higher your tax rate goes up, the percentage, the longer you're married, the higher that durational alimony percentage goes up. So if you were married, for example, for 40 years, your worst case scenario would be paying an alimony for 30 years, because that'd be 75% of the duration. And that's considered a long-term marriage. In a perfect world, if there is a threat of paying alimony, you'd want to get divorced within that first 10 years. That's your, best case scenario. So that's the durational cap. Now, that does not mean that automatically, by operation of law, you're going to be paying alimony for half the duration of your marriage, or 60% or 75% of the duration of your marriage. Doesn't mean that. It just means that you can't pay more than that in durational alimony. It is a cap. It doesn't say that that's what the person receives. It just says that they can't receive alimony longer than that period of time. There's also an amount cap. And the amount is going to be capped at 35% of the difference between the net incomes of each party. It does not mean that that is how you calculate alimony. That is definitely not how you calculate alimony. Alimony is not going to always be across the board 35% of the difference between the net incomes. That is just a cap. Worst case scenario, you make a lot more money than your spouse. Your spouse demonstrates in court that they have a need for money. They demonstrate in court that you have the ability to pay. It doesn't matter how big their deficit is or how big your surplus is. The maximum that you're ever going to have to pay is going to be 35% of the difference between the net incomes. Now, this is law, so there's caveats to everything. That's the general rule. There's some caveats if your spouse was disabled during the marriage, not before, but during the marriage, and it's a legitimate disability that they can prove in court, and it shows that they're going to need ongoing care. They're going to have an inability to go out and get meaningful employment, stuff like that. The judges have a little bit of latitude to adjust and get around those caps, but that does not happen very often at all. It's just something that everybody should be aware of. So alimony is actually going to be calculated, like I said earlier, based on the financial affidavits, the need and the ability to pay. And then whatever that alimony amount is, then that cap is going to have to be applied. And that cap might reduce that amount of alimony. So, for example, if 35% of the difference between the net incomes is $3,500 a month, let's say that's the cap, but you have a $5,000 a month surplus and your spouse shows that they need $5,000 a month in income, that $5,000 is going to be reduced to $3,500. Okay? Let's say the same scenario. Let's say the cap is $3,500 a month, but your spouse demonstrates that they need $2,000 and can demonstrate that you do have a $2,000 a month surplus. Your alimony is going to be $2,000. It's not going to be increased to $3,500. So it just can't be more than the cap unless those caveats exist. So really, what a divorce lawyer is trying to do in Florida, if you're the person pursuing alimony, the divorce lawyer is going to be seeking to show that you have a financial need and that your spouse has the ability to pay, and vice versa. If your divorce lawyer is, helping you to defend against an alimony claim, your divorce lawyer is going to try to pick apart what your spouse is claiming as reasonable and necessary expenses to show that they're not legitimate, that they don't really need that amount of money to try to reduce their deficit, or that they're capable of making more money. and that they're choosing to be underemployed, for example. You can make those arguments. And likewise, if you're defending an alimony claim, your lawyer is going to be trying to show that all of your expenses are reasonable and necessary for whatever reason. And that reduces your ability to pay the alimony. And a lot of cases don't go to trial. A lot of divorce cases are going to settle at mediation. But it's very important to understand how alimony is calculated, how the judges view alimony, what the judges think are important, because that's how you negotiate. When you go to these mediations, you got to think about, hey, if we don't settle today, what's my worst case scenario? What's my best case scenario? What's the middle of the road scenario? And that's how you know whether or not a deal at mediation is good or bad. So it's important to understand those things. As far as the other forms of alimony go, rehabilitative and bridge the gap alimony, I said at the beginning that those are pretty rare. We don't see those a whole lot. Those are really going to be in situations where, they're going to be very short-term marriage. We're talking like a year and a half, 2 years. And there's another general rule in Florida, which I forgot to mention. This is important. You can't get durational alimony in Florida until you've been married at least 3 years. Once you hit the 3-year mark, then durational alimony kind of comes into play. But if you're in a marriage less than 3 years, durational alimony is usually off the table. It's not even worth seeking. Judges award it so rarely, and there's actually statutes on this point that say that durational alimony doesn't kick in until you've been married at least 3 years. But even if you've been married a year and a half, let's say you were going to school to study nursing and you got your LPN license and you were 6 months away from getting an RN license, where an LPN might be making $30,000 a year, an RN might be making $60,000 to $80,000 a year. That's a huge difference in earning capacity. So let's say when you got married, you were really close to getting that RN degree. You're 6 months short. You just had 2 semesters left, but you got married. And let's say your husband told you, hey, forget it. I'm going to take care of you. Like, just drop out of school. We're good. And you agreed with that. And you were a, stay-at-home wife, could be mom, doesn't matter. And, after a year and a half, 2 years, you want a divorce or your husband wants a divorce. Doesn't matter who wants a divorce. Even though you haven't hit that 3-year mark where durational alimony kicks in, you still might get some rehabilitative alimony or bridge the gap alimony, which means very short-term alimony. In this case, maybe you get 6 months of alimony for you to finish your RN degree. That's reasonable under the circumstances. It was a marital decision for you to stop pursuing that education. As a result of not pursuing that education, your income is capped at $30,000 versus $60,000 to $80,000, and you only need 6 months to finish school. So it would make sense, even in a short-term marriage where durational alimony doesn't apply, to maybe get some bridge the gap alimony. Let's do 6 months, husband continues to pay the bills while you get that RN degree. You still have to prove it, though. You still have to prove how much money you're going to need for your living expenses, for tuition. You're going to need to prove that you're re-enrolling in school to pursue that RN license. You need to take steps. It's not just he said, she said. You can't just go to court and say, well, I need 6 months of alimony to finish my RN degree. The judge is going to say, okay, cool. Did you get re-enrolled in school? When's your start date? Where are you going to be living? You living in on-campus housing, off-campus housing? What are the expenses? How much are your books? You're going to want to know that information. You got to prove that that's what it would take, a specific amount of money to get you through those 6 months for you to get that degree. So like I said, doesn't happen very often. A lot of times we're analyzing cases from a durational alimony standpoint, but it's always good to keep in mind these other forms of alimony that are out there. And let's talk about how alimony is paid. Most often, alimony is going to be paid on a monthly basis. And the person paying the alimony cannot claim that alimony on their taxes. If you look at the tax code, you're not going to see alimony as a line item that you can deduct. So that's going to be after-tax income. But when you pay it to the other spouse, the spouse that receives the alimony, that's not going to be considered taxable income. They're not going to pay taxes on that alimony income. So you're the one that's going to be paying the taxes. So it's important to remember that if you're in a 20% tax bracket and you're paying $2,000 a month in alimony, that alimony is really not costing you $2,000. It's going to cost you $2,400 because you're paying $400 a month tax on top of that alimony. Likewise, the person that's receiving the alimony, even if, let's say, they're in a 10% tax bracket, they're still receiving that $2,000. They're not going to receive $1,800 because they're not going to pay that $200 tax on it. That's an important thing to consider. But alimony is usually going to be in monthly payments because alimony is going to be based upon, when bills are becoming due. Bills are typically due on a monthly basis. People typically need money on a monthly basis. That's how alimony is typically paid. But the judge can structure it any way that the judge thinks is fair or might work. Alimony could be in quarterly payments. It could be in annual payments. So, for example, if somebody does have like a sales job, right, and you're getting a divorce and your spouse is entitled to alimony, let's say it's $2,000 a month, that's $24,000 a year. But let's say the person only earns a commission on their sales every 6 months. So the person that's working the sales job that has to pay the alimony, their base salary might cover their monthly living expenses, but just barely. So like on a month-to-month basis, they're just breaking even. They don't have a big surplus. But let's say for the last 3 years, they've been receiving a commission check every 6 months for $20,000. Well, the judge might make under that circumstance that your monthly alimony payments are due when you receive that 6-month commission check. So when you receive your check in July, you might have to pay your spouse $12,000. When you receive your commission check in January, you pay your spouse another $12,000. That equals $2,000 a month, but it's going to be more fair for you to pay it when the commission check hits your account and not just on a monthly basis. And then we can also structure settlements that way. There's a whole lot that goes into it. The whole purpose is not to just completely bankrupt one person. It's got, any result has to be fair. It has to be equitable. And again, like I said, if you ask anybody that's paying alimony and you say, hey, do you think it's fair or equitable that you're paying alimony? 99 out of 100 people are going to say, no, I got screwed. It's BS. It's not fair. But you know what? If you ask anybody that's receiving the alimony, if you think that it's fair, they're probably going to say, yes, it is fair. It is equitable. So it really depends on what side of the aisle you're on. But at the end of the day, the judge and the lawyers are looking at it objectively. Like what is fair? What is equitable under all of the circumstances? Alimony can also be paid in lump sum. So let's say you're in a divorce, you got a house, it's got $400,000 of equity. And you're going to have to sell the house as a result of the divorce. And you normally would split that equity 50-50. You get $200K, spouse gets $200K. But let's also say that you've got to pay $2,000 a month alimony for 5 years. Well, that's going to be about, I don't know, again, I'll have the math. Let's say it's 120 grand total alimony over that period of time. You can structure a divorce settlement so that when that house sells, instead of paying $2,000 a month for 5 years, you can just give more of your share of the equity to your spouse. And a lot of times you can even get a deal. You can get a discount because money today is more valuable than money in the future. So let's say you got your total alimony liability is $120,000 over 5 years. But when you sell that house, you're each going to get $200,000. You could negotiate and say, look, I'll take 100, you take 300, but then you waive alimony. You're saving $20,000 over 5 years because the other person's getting the money today. That's a much more attractive deal to get $100,000 lump sum than $120,000 over 5 years. Also, you're not going to have those monthly obligations. You're not going to have those continuing commitments. The other good thing about doing that is alimony in Florida, unless you agree that it's non-modifiable, alimony is modifiable. And even when it's called non-modifiable, it still can be modified under certain situations. So what do I say modifiable? Well, if your net incomes are at a certain level when you get divorced and you're ordered to pay alimony for 5 years, let's say, and a year after the divorce, your job just starts ripping, you start making a lot more money. Your spouse could file a modification petition to increase your alimony because you're still within the alimony payment window. So that alimony can be modified. They're still going to have to prove that they have need, that you have the ability to pay, and it kind of goes through the whole same calculation and the same caps apply and all that. But if you kind of want to lock in your rate, so to speak, when you get divorced, paying it lump sum and then having the spouse waive alimony means that you could start making $1 million a year the next year. It can't be modified. So there's some benefits to doing it that way. And those are all things that, any good divorce lawyer is going to look into during the case. This is where you often hear those stories. You're talking to a guy on the golf course and he's, complaining about his divorce, and he says, "Oh, she got the house and, we had to sell the house and she got all the money and she got to keep the car and she got half of my retirement account. I got totally screwed." What that person is probably leaving out is that they were making significantly more money than their spouse in this situation. And the reason why the wife got the house free and clear or got all the equity from the sale of the house was probably because that guy made a calculated decision to pay the alimony lump sum versus pay it on a monthly basis. So when you're hearing that kind of story, you got to keep in mind that, yes, he had to give her the entire house. But what that person might be leaving out is they did that so they don't have to pay any alimony for 10, 15, 20 years. So there's still a benefit that that person is getting from giving their spouse the entire house. But at the end of the day, it's all math. One gender does not automatically get screwed in divorce cases. It's really just not that simple. And I'm not even being, woke or progressive in saying that. I mean, I'm just talking from experience. I've seen women paying alimony. I've seen men paying alimony. I've seen women lose all their stuff. I've seen men lose all their stuff. It really just kind of boils down to the math. It's really just going to be a mathematical equations. And it's going to be about what expenses are you going to be able to prove are reasonable and necessary? What expenses that your spouse is claiming are unreasonable or unnecessary? And that really kind of comes down to the discovery. And that's why it's important to invest in a divorce case. If you really have a big alimony claim that you're looking at, you're going to want to take your spouse's deposition because you're going to want to sit them down under oath and go through their expenses. You're going to want to spend the time and effort and have your lawyers do full mandatory financial disclosure. You might want to hire a forensic accountant to go through your spouse's bank accounts, every single one of their credit card statements, and line item these things to verify if what they're claiming as expenses, they're really in fact spending that money. If they say on their financial affidavit that they're spending $200 a month on gas, but you go through their checking account statements, you go through their credit card statements, and you add up for the last year, every dollar they've spent at a gas station, and that number comes to less than $200 a month, well, that's some really good, compelling evidence that you could then take to mediation, take to court to show this person's full of crap. They're not spending $200 a month on gas. They're spending $100 a month on gas. And you can kind of extrapolate that through every level of expense. And so that's really what investing in a divorce means. To get the fairest outcome, to get an equitable outcome, to get a more favorable outcome for you, whether you're defending against an alimony claim or pursuing an alimony claim, investing in doing the digging, investing in doing your due diligence is what's going to get you a more favorable outcome. People that don't do the work get blindsided by an alimony payment that they can't afford to pay. And then they complain about how they got screwed in a divorce because they're paying their spouse $4,000 a month in alimony, and the spouse never really needed it to begin with. They also work a decent job, make good money, have wealthy parents, don't have really high expenses. You're struggling paycheck to paycheck paying this alimony, and these people are going to complain, I got completely screwed. Well, why was that? Probably because you didn't want to invest in doing the digging. You didn't want to do all the due diligence. You didn't want to hire the forensic accountant. You didn't want to pursue the motion to compel to get the 2 years of the credit card statements. Or you didn't want to pay to have the deposition taken. So sometimes you can cut off your nose to spite your face, so to speak, when it comes to these alimony claims. Same thing if you're the one pursuing alimony, and ultimately as a result of the divorce, whether it's by settlement or court order, you find out that, hey, I think it's BS. I should be getting a lot more money in alimony. We were married 15 years. I took care of all the kids. The only reason he was able to go work this job and build his career is because of me. And now he's making all this money. He's only paying me $1,000 a month in alimony, and you'll hear people complain about that. Well, I mean, did you pay the lawyer to take the deposition? Did you insist on full and fair mandatory disclosure? Did you get every single document? Did you see every bank account? Did you get every credit card? Did you hire the forensic accountant? Did you do anything to verify whether or not their expenses that they're claiming are reasonable and necessary? Probably not in those situations. So if you do the work, you'd be surprised you get a better outcome. That's really what we do here at Fairway Law Group. The whole point is that we're trying to give our clients the most bang for the buck. But at the end of the day, when it comes to divorce, you really get what you pay for, not just from a quality standpoint or quality of lawyers, but also you could go and hire the best lawyer in the world. It doesn't matter. You could hire the absolute best divorce lawyer in the state of Florida, but only give them a $5,000 retainer. Do you think you're going to get the best result? Probably not. Because that lawyer is going to have handcuffs. That lawyer is going to think, okay, how can I get this person the best result, but with just such a small budget? So you're really just going to tackle the main things, the biggest issues, but it's probably not going to go far enough to really get you the best result. So a lot of times I think the quality of the lawyer does certainly matter, but more so than the quality of the lawyer is, assuming that you're hiring a quality lawyer to begin with, you got to give that lawyer enough resources to be able to investigate the case, to build the case, to bring the case properly so that you can get a good result. A lot of times when you do hear people complain about the result, it's going to be people who probably were very budget conscious, didn't want to spend the money, didn't want to go out and hire the experts, do the digging. That really was necessary in a case. Here at our law firm, we do both sides. We represent people who are seeking alimony. We represent people who are defending alimony. There are some law firms that only deal with people who are defending alimony claims. I think that doing both sides makes us better at doing it because we know the arguments to get it. We know the arguments to avoid it or to try to avoid it. And I think that both of those things are helpful to people when they're getting a divorce. And, it doesn't matter if you're making $40,000, your spouse makes $50,000. They're only making $10,000 more than you. It might still be worth making an alimony claim because, again, it doesn't just depend on the total amount of money that they're making. It also depends on the expenses and things that they're claiming. So if your reasonable and necessary expenses are going to put you in a deficit, even if they're only making $10,000 more than you, but they're going to have a surplus, alimony could still be on the table. So it's always worth pursuing in every case. The only time you would not pursue alimony is when you're the one making a lot more money than your spouse. If you're making a lot more money than your spouse, it would just be silly and stupid to pursue an alimony claim, and you're going to lose a lot of credibility. But if you're the one making less money than your spouse, you're probably always going to pursue alimony, whether or not you're entitled to it. If you're the person that's making more, you're probably always going to be defending alimony. Even if alimony is not initially requested in a case, you still need to handle the case as if it might be, because the person could, maybe mediation breaks down, you guys don't reach a settlement, and then all of a sudden you're hit with an amended petition seeking alimony. So you need to work up the case from the beginning, either pursuing alimony or defending alimony, regardless of whether or not it's even included in the petition. It's always something that should be on our minds. Well, that's kind of alimony in Florida in a nutshell. There's obviously a lot more to it, but those are the main highlights. Those are the things that you want to consider and always have, kind of that analysis in your head whenever you're thinking about getting a divorce or looking at what your life might be after a divorce.